Well, hello and welcome. My name is Amanda Moore. I'm a senior attorney editor at the Sargent Shriver National Center on Poverty Law. And at the Shriver Center, we publish Clearinghouse Review, Journal of Poverty Law and Policy. This is our second hangout where we featured an author from our current issue of Clearinghouse Review. And I'm happy to say that our featured guest today is John Bowman, the president of the Shriver Center. Hi, John. How are you?
I'm good. How are you?
Doing just fine. I'm in Tennessee and it's freezing, so I don't even want to know what the weather is in Chicago, I don't think.
I don't either.
Okay, just stay holed up.
I'm ignoring it.
Exactly. Well, I want to welcome all of you for joining us today. We're here because John has a great article in our September-October issue of Clearinghouse Review. His article is called 6 Steps to Broader Impact. This was a great article for our September-October issue because it focused on, the entire issue focused on affirmative advocacy. It's that idea of taking a direct services, high volume practice and looking for ways to take a different approach to advocacy that might benefit a broader group of clients. And John's article is wonderful. It goes through 6 steps, a very practical piece of how to incorporate that type of advocacy into your practice. So I want to welcome all of you who have joined us today. I know you might be watching us in one of 2 ways. One way is if you have logged in through your Google Plus account. And if you have done that, you have the ability to ask questions during this hangout with John Bowman. Don't worry, he won't appear on screen or anything like that. But what you can do is in the top right corner of your screen, you'll see a little grid of 9 squares. And if you click on that, you'll see an icon that's blue and says Q&A. And if you click on that, you should see a chat box open down the right side of your screen. And that's the way you can submit questions to ask during this hangout. And we encourage you to do that. We welcome your questions. We want them. This is an opportunity for our readers to have a conversation, basically, with one of our authors in a
yeah, so bring it on.
That's right. So if you have that open now, go ahead, feel free to test it out. You can send us your name and where you're watching. We'd like to see that too, and then you can get a little familiar with the technology. I know others of you are watching us through a live stream on the Shriver Center's YouTube channel, and we welcome you too. While we're waiting for everyone to get their Q&A box open, I'll say a bit about John before we start with the questions. John has been at the Shriver Center since 1996, and before that he spent a couple decades at the Legal Assistance Foundation of Chicago, where he was doing public benefits work, both direct services work as well as some of the impact advocacy. So he's well positioned to write about this topic and how to incorporate more of this broad-based advocacy into your practice. So I will start off with a question before we get any from our audience. John, can you just give us, for someone who hasn't seen this in action yet, can you give us an example or 2 of what you mean by this? What would it look in practice to take something that people see in their legal services practice and try to have a more affirmative approach to addressing that?
Sure. So the example I use several times in the piece is a situation where over a period of a few weeks or a couple months, you have case after case where a trial judge is making incorrect decisions in eviction proceedings, perhaps in cases where you've given pro se advice. You know, this is a bad 5-day notice, go in there and move to dismiss, and the judge makes the wrong decision. And so you've got a point where there's been several of these, and what I suggest in the piece is that there's a set of questions to ask about whether there might be it might be a useful issue to consider a broader based approach to, and then if the answer is yes, some initial steps for teeing up a broader based approach for an actual final decision about whether to proceed, and if you're going to proceed, what it's going to be. And so it's a way to think through repetitive issues that come through the door, or issues that happen to the same person over and over and over again because of some systemic thing, where there's no remedy, or there's no program, or there's a mistake being made, or a barrier being erected, or something that's causing lots of people to get sick or become homeless. And it's a way to sort of process that and say, is there something comprehensive that we can do that would attack this whole thing, fix this whole problem, eliminate this whole category of cases? And so that's what I'm suggesting here, is a way to, kind of operationalize a routine set of questions where if the answers keep being yes, then you also proceed to the next step and do the next set of things, and you end up with broader impact initiatives. They're not always cases. Maybe there are other strategies, but that's part of the process.
Right, and I should tell people, if you have not been able to read John's article yet, you can find this on the Shriver Center website. That's povertylaw.org, and you'll see Clearinghouse Review there, and you can go there and see the current issue and find John's article. I think that there's a large desire among public interest lawyers to do more of this broad-based advocacy, but I think a lot of times attorneys feel, especially if they're in programs with restrictions, that their hands are tied and they can't really do this type of work. Is that the case? Is this something that can be incorporated into any legal services program?
Yeah, and I think it can especially be incorporated there because it helps to get past that attitude where you assume your hands are tied, but maybe they're not. And it also helps you get to a point where even if your hands are tied, you're making a smart and good referral. So I strongly recommend that you go through this whole process with the issues that pop up. And because by the end of the process, you may have, through research and so forth, come up with a menu of possible actions, some of which are restricted activity and some of which may not be. And so maybe you refer the client for some of it and keep others of it. So for example, in the eviction example, if one of the solutions might be to try to change the landlord-tenant law to firm up some concepts there, well, that would have to then be a referral because that's legislative activity. But another strategy might be to tee up a systematic stare decisis project where you take appeals. It may be a court watch where you keep track of what the judge does every day, and then you use a media strategy or an approach to a chief judge to effect a change, none of which is restricted activity. And you may decide to do all of that simultaneously. So if you went into it on the front end saying, this is an area where we can't work, you wouldn't come out the back end with as smart a resolution, even if it is a referral.
Right. And one thing I thought was really interesting in your article is that looking at whether it's possible, you put as one of the later steps in the process. So people don't knock out these other possibilities just by saying up front, we can't do this. That question actually comes up pretty late in your process.
Yeah, it comes up at the end, actually. So once you decide, yes, it's an impact project, yes, it makes sense, yes, it's important to the clients, yes, it's a justified use of resources given what our mission is in this world and in our organizations, but no, we're restricted. Then you make the referral, but that's a good outcome. That's a valuable process, and I think you've helped to tee it up for success.
Right. So we have our first question. He's come through from Hannah. Thank you, Hannah. And I want to remind others who are watching through their Google Plus accounts that we do have a Q&A app enabled, so you can ask questions of John. If you weren't on when we first explained this, in your top right corner of your screen, you'll see a little grid of 9 boxes. You can click that. Then you'll see a blue icon that says Q&A. You can click that, and then your chat box will appear on the right side of your screen. And we encourage your questions. Please send those in. So our question from Hannah is, how do you carefully analyze whether an affirmative approach could set bad precedent?
Well, I think that's part of the process. In the what I suggest is in the first step, you just sort of identify that there's an issue that that might be appropriate for broader impact, and sort of an initial process of power analysis and potential research subjects that get you to the decision, yes, we're going to proceed, and what we proceed with isn't the initiative itself, but it's a research action, I call it, that has independent status, should have independent status in work plans and case reporting and credit or in annual reviews that people do. And in that research action, then you identify the landscape. What is and part of identifying the landscape is conversations with our valuable allies in national backup centers and in our own communities, the veteran advocates in these subject matters. They're the ones that can tell you, yeah, that might look like a good cause of action. It might technically be one, but there's some problems in the courts right now, and there's some danger about setting bad precedents. So maybe you want to consider other ways of attacking the problem if you can. In other words, you get that kind of advice and feedback so you can make your decision. Once you get into the research action and prepare the memo about whether to proceed on the project.
So I think that touches on something that you mentioned in the article, this idea of community lawyering. Not everyone is familiar with that term. Could you explain a little bit about what that is and how that can help a program who's making change to incorporating some affirmative advocacy?
Yeah. So what community lawyering can do, what it is the representation of community-based leaders and community-based groups, particularly groups. And essentially you're their lawyer, and you are a resource for them to address their agenda that they've generated through their own sort of legitimizing processes on the community level. So if you represent groups like that and they bring impact issues to you, then that's a perfectly legitimate way to carry out what I have written down here as step one, where if you're not representing community groups, you just make a judgment based on the flow of cases who walk through the door and what are the repetitive ones and so on. But if you're representing a community group, they will bring that agenda to you for broader action, and then you can put it through the rest of the process, the research action, the power analysis, the potential types of ways to address it, and working with those group clients, community-based clients, you decide on which actions to take.
And is that something that any program can do? Is that a restricted activity?
Yes. Yes, I believe so.
It is something anyone can do.
However, I haven't been in a restricted environment since 1996, so you have to be sure to check those kinds of answers. Don't take my word for it. You have your own bosses and leaders who will inform you about it.
Got it. I see we have some people testing out the Q&A, so it is working. Yes, so please send us your questions or comments, anything. And they don't necessarily have to be about John's article if you haven't read it yet. If you have questions about affirmative advocacy or about John's history at LAF or with the Shriver Center and the work the Shriver Center is doing now, we welcome those questions as well.
What I had for breakfast.
What John had for breakfast, yes, any of those things. Guilty pleasures, that's always one of my favorite questions. I may not put you on the spot with that. One other term that you mentioned.
Too many of them.
I'm sorry?
There's way too many of them.
Take the rest of our time. One other term that you mentioned when you were answering Hannah's question was research action. And I think that's a term that maybe people aren't familiar with if they don't come from a community organizing background. So could you explain, and a lot of your article talks about the research action and how important that is. Could you speak a little bit more about what that is and what it looks like in these steps?
Well, yeah, there's a whole set of community organizing terms and skill sets and kind of thought processes that went into this. I've been more and more impressed with that particular skill set as I've grown older or more experienced and had more and more to do with organizers. And, you know, like lawyers, there's good ones and bad ones, so you have to use some judgment about that. But there's certain concepts. One is the research action. They call it an action to put it on an equal footing with, like, going and doing a demonstration at their congressman's office, or going and doing a meeting with an editorial board of a paper, because doing the research itself is an action. It's taking, it's propelling something forward, and it's not being passive but acting, and getting the information and research you need in order to make a good decision about whether and how to proceed needs to have independent stature and respect and credit within organizational evaluations and so on, in order for you to be really serious about having a broader impact practice. Other terms that I've used in here, one is the power analysis, right? So you know what the problem is, who has control over it out there, and how do we influence them, or how do we force them, or how do we get to them so that they'll exercise their power to fix whatever the problem is. So that power analysis is important, so you don't go off in the wrong direction, and that you're smart about where you're aiming things. And another one, way at the end, I think is critically important, is evaluation. That's my sixth step, especially to the extent that this is something new, but even if it's something old, you should always take a little time to reflect on it, learn from it, tweak it, make it better, and be clear-eyed about whether something worked or didn't work. I love the quote from the old organizer whose book I used for footnotes in this piece, Ed Chambers, who was Saul Alinsky's successor, is that evaluation helps us to not believe our own propaganda, right? That we're ruthless with ourselves in evaluating things and making sure we're doing, improving as we go along.
Right. Yeah, I think you touched on a couple of things that probably are questions people have. Pressure from funders, other things to show these numbers, and that if you can find a way to incorporate those research actions into the actual accounted work of the organization, then that's something. It's not a waste of time.
Well, and the early footnotes in this piece are to LSC regulations and ABA standards that call for broader impact. So in LSC's case, the same organization that's calling for the numbers is also calling for broader impact. So there should be some way to communicate the value of research actions there.
Right. And the power analysis point, I've seen people do power mapping, which is really interesting, actually draw it out, arrows and boxes and lines, and it's really helpful.
And I've seen it, in Illinois here, for example, we have like many people do, a powerful Speaker of the House, right? So sometimes I've seen it mapped out on a page. We've got, who is this guy? What makes him tick? Where did he come from? What Roman Catholic schools did he go to? Is there people he listens to? Who are they? What makes him tick? And that begins to give you a sense for how to mount some sort of effort to get him to use the power to fix the problem.
Right. We just had another question come in from Jax.
Hey, Jack.
He says, John, from your friends in St. Louis, Missouri, what kind of affirmative approaches do you see as options for a restricted program to have a broader impact on low-income individuals living in Ferguson and St. Louis County?
Well, I think it needs to be directed at what the problem is that you're trying to solve, and I assume there's many. And I think you have to make a judgment about which of them relate to the mission of LSEM. So which are the ones that are the most about poverty, in other words. Now, if the issue is policing, in a restricted environment, I think what you're talking about then is not necessary. You can't be thinking about legislation, and you can't really be thinking about class action litigation against, the police force or somebody. But you can be thinking about representing the groups on the ground who live in the community, who are comprised of people in poverty, and addressing the issues that they bring to the table about this, right? So, is it harder to get to work? Is it certain police practices not making the community safer, and therefore the kids don't get to school? Or, in other words, you break it down to, this is another organizing concept that I talk about in the piece. You take the problem, which is Ferguson, and that's what activates you and gets you interested, but then you have to break it down into actionable issues, right? You can't, there's very little that a legal aid office might be able to do to sort of fix Ferguson. And yet, if you break it into actionable issues, is there, and here it almost certainly has to have a racial justice lens. So is there redlining? Is there equal treatment in school discipline? Is there open communication between the police department and the community organizations regarding positive policing, you know, making sure things are safe, making sure that actual criminals aren't prevailing, or I don't know what it might be. But you break it down into actionable issues. How about health disparities? Is there a chance with the Affordable Care Act changes? I don't know how far Missouri might have gone with that, but to bring some behavioral health solutions to community problems that make them health issues and not policing issues. In any event, that part of the research action is to break it down into actionable issues and do the research about those issues, and then you have a menu of things. But there's a lot that can be done there through research, through media strategies, through just meetings and pressure, through empowering the community group to be more effective in its work, transactional work, maybe there's real estate things. So I hope that's helpful.
Thanks, John. For people who are interested in this and going beyond your article, what are some resources that are out there that you would recommend for either individuals or organizations wanting to do more affirmative advocacy?
Well, I think it's always important to touch base with the people who already are doing this well. And I would say, so for example, I ran this article by Joel Ferber at Legal Services of Eastern Missouri and Carrie Chapman at the Legal Assistance Foundation of Chicago, because you know, I haven't actually done direct service in probably 25 or more years, so it's a little presumptuous of me to even write this thing. And I wanted to make sure from them that this might be helpful. Relationships with the people in the backup centers who can quickly answer questions that will save you hours of research. So it's useful to have those kinds of relationships even when you don't have something to ask them. And they need you too. They need to know what's going on the ground. I think the whole community organizing, not the whole literature, but some useful literature about it, or even a course. They don't teach it in most law schools, I dare say, but it is an incredibly useful skill set. And I cite this one book, but that's just one book among many. And the Industrial Areas Foundation, where that comes from, there's other tribes of organizers and different strategies there, but it generally speaking, a very good skill set and very helpful in understanding what community-based organizers and leaders are trying to do, and that communication is essential.
We have one more question, and then this will probably be the last question we can take. This one's from Susan. She says, client stories from restricted programs often provide a great narrative background for the unrestricted legislative work done by my office. Creative ideas for how to increase the comfort of restricted programs in sharing these stories.
Yeah, well, I would say that if you go through the process or something like it that I recommend in this piece, you will have that. You will have, you know, because you will have identified the cases that came through the door that caused you to go through the process, right? And so you'll come out the other end and say, you know, we really need legislative change here, but we have all these cases, so let's refer all these to the people who can do that work. And that's what it is. It's a referral. It doesn't, it transmits the stories before there's any pending legislation. And then it gives you the referral to make, you know, kind of at the front door when cases continue to come to you. So I think the way I read the restrictions and so on, but again, get your own answers, this doesn't, none of what I just described would create a problem, even as it does improve the comfort level with collecting the stories and referring them to the people doing that work.
Right. So it almost sounds like share this article with your friends in the restricted programs. Increase their comfort with it. To say this is okay. There's a way to do it.
Yeah.
Okay. Well, we have these half hours go very quickly, even when you're not eating lunch. So yeah, we're already to the end. But I can't let you go, John, without talking about baseball just a bit, because I know you're a huge baseball fan and a big Cubs fan. So I have to ask.
I'm really excited about the Cubs, although as of yesterday, everything's ruined for the moment because Russell Martin went to Toronto instead of coming to the Cubs. But we're going to get John Lester, and we got all those rookies coming up. And watch out, Cardinals. Watch out, Brewers. Watch out, everybody else. Here come
the Cubs. I love that. It's this. I think it's that eternal sense of hope. It's a necessary quality for legal services lawyers and Cubs fans. So.
Somebody asked me, how can you keep doing this work? You know, there's always poverty. And I said, I'm a Cub fan.
Exactly. Exactly.
Every year.
Right. Well, I want to thank everyone who joined us today, and those were terrific questions. Thank you for submitting them. If you had a question, or if you think about this more, if you go read John's article and then have a question, I've checked with him. He says it's okay for me to do this. He'd be happy to hear from you. His email address is John Bowman, JOHNBOUMAN, @povertylaw.org. So feel free to send him any questions you have, and he can answer them or connect you with people who may be doing what you are asking about. And I'll also say keep watch on your inboxes for notice of our next Google Hangout that we'll have. That will feature an author from our forthcoming November-December issue of Clearinghouse Review. So John, thank you again for being with us today.
Thanks, everybody.
All right, and thanks all of you. Bye-bye.